All right, guys. Hey, good morning. I fully intended to record this before I left, but I didn't. So here we are. This is not the worst location in the world for me to record a training video. But yeah, I just wanted to make sure we got this to you in a timely fashion. And today's topic is about listing agreements. And I'm just going to go through a couple scenarios. This isn't going to be an hour in length. There's just a couple issues that keep coming up over and over and over that I want to make sure that you guys are all aware of, so that we don't have any issues in the future. So I'm just going to do a screen share. We're going to start. Get situated really quick. We're going to start with the flex form, the authorization and exclusive right to sell. And I'm just going to kind of go back and forth between here and my notes on what I think it's most important for us to talk about today. So obviously, this is the form that you would be executing with a seller of a property in the event that you're listing a property. Now, this is not the only way to obtain legal authority to list a property for sale, but it would be the most preferred and the most common form. There are some other ways to list a property for sale, and we're not going to go into it on this call because they're so rare and honestly not really recommended. You might remember them from pre-licensing, the exclusive agency option, and things like that. Plus, there are some companies or some entities that require that you get this sort of authorization on a form that maybe their attorney drafted up or something like that. And again, if that comes up, let's just talk about it on a case-by-case scenario, because I think that's so few and far between. 99% of the time, this will be the form that you're using. Now, in Alaska, it is in state statute that you must have express permission to list a property for sale. Express meaning what? In writing, right? So without the express permission to list a property for sale, you would be breaking the law. And so maybe you have a friend or a family member, you're like, hey, we're going to put your house on the market. I see this happen a lot in new construction. And you maybe do this paperwork after. That is a problem because that technically is breaking state statute. Now, we are not required when representing buyers to have a contractual representation agreement prior to working with them, only a disclosure of what the licensee relationships look like. But with a seller, it is different. You must have express permission. So let's just get into this. And we'll talk about like the most common issues that we see in this. But I just first want to start out, and I'm going to scroll through my phone a little bit because I have a lot of my notes on here. Actually, I'm going to pull my notes up on my computer. It'll just be easier that way. Okay. So we're going to first start with like setting the stage. I think a lot of the issues that come up when it pertains to listing agreements happens or could be resolved at the time of the listing appointment, prior to ever receiving any offers, prior to ever having any sort of transactional issues come up. A lot of these problems can be solved at the time of the listing appointment. So one of the things that you need to be discussing at the listing appointment is like, how are we going to operate? That can entail like, how are we going to enter into relationship together? What if I have a buyer that wants to purchase your property? How often are you going to be hearing from me? That's the number one complaint I get is like, how often are you going to be hearing from me? And that, you're making a commitment to them that those are the times that you will be communicating with them on the updates of their listing while it's being listed for sale. How much am I going to charge for this? And who's getting paid out of that money? At our anticipated listed price of, let's say, 400,000, how much could I expect to yield at the end as profits at the end? Are there does a variable rate commission exist? Meaning if I bring a buyer to the property, my commission percentage changes. And then we're going to just slightly touch on some best practices for sell by owners, where you're not necessarily the listing agent, but you're representing the buyer, and you end up doing probably a lot of the duties that a listing agent might do in the event that you're working with a for sell by owner on the other end. So those are some of the things we're going to talk about. We're just going to start with the listing agreement, though. So up here, you're going to be writing the seller's name, obviously. What's some things we need to be thinking about? One of the things that I see is that sometimes not all parties that are entitled to the property are being listed in this seller box. That can be an issue. Also, like in terms of like if an entity, if it's being purchased or sold from an entity in a state, making sure that you have the proper documentation that the person that's entering into this contractual agreement actually has the legal authority to do so. So you want to check that. Obviously, by pulling up their profile on the Matsu Borough, the municipality, if you're in the Kenai Bureau, pulling it up there and making sure that the person that's entering into the contractual agreement has the legal authority to do so, or has been granted that through a court document. So hereby employs grants. This should be, this first name brokerage company should be Signature Real Estate. Designated licensee would be your name, and if it's a co-listing with somebody else here in the office or whatever, the name of the licensee needs to be on the listing agreement. If you are co-listing with a licensee outside of our brokerage, both brokerages must be listed and both licensees' names must be listed. The next part, the commencement date and the expiration date. So in order for this to be a legal binding contract, it must have a commencement date, which is a start date, and an end date. We see these left blank a lot, and that will no longer be acceptable in file compliance. So you must fill this in. Area, zip code, which recording district you're in. So depending on where the property is located, if you're in the Matsu Valley, 9 times out of 10, it's going to be in the Palmer recording district. Even if it's in Wasilla, if you're in Talkeetna, then it's probably going to be in the Talkeetna recording district. There are a couple parts of the valley, like over by the Butte, Kinnick River Road area, Goat Creek area, that would fall within the municipality of Anchorage. So that would be in the Anchorage recording district. And then obviously anything in the municipality would be Anchorage. Then we also have the Kenai recording district, so on and so forth. Address of the property, legal description of the property, both of these need to be filled in. All right, next, this is probably where 99% of the problems happen. Seller hereby authorizes, or seller hereby, and then you have the check boxes A, B, C, D. I would say 90% of the time, people are checking A. Sorry, this is not the point. Sorry, this is one of our big issues, but also paragraph 2. So we'll get into that in a minute. So let's say that your listing is going to start December 1st. It is now November 29th. So December 1st, if you are checking box A, what MLS rules says is that if I put that the listing agreement starts on today, let's say, and I check box A, that I authorize the broker to commence marketing, showing, and publication of the property in AK MLS database, I have 3 business days to do this, to where I would not be fined by MLS. This date right here, the date of commencement, should be the date that is entered into MLS. So I know a lot of times we don't want to put that date on there, and then like the first day on the market, it shows 3 days on the market. So make sure you really pay attention to what that date is and what the actual commencement date of the listing contract is. It is not against MLS rules to take a future listing agreement. So if like I didn't have any intention of putting a house on the market until December 5th, I would write December 5th as my date. Does that mean they could sell it on their own or in accordance with another listing contract prior to that date? Yes, it does. but our paperwork should really match what is actually going to happen. Option B, authorizes broker to commence marketing in a coming soon status in AKMLS prior to actively showing the property. So what is coming soon status? Coming soon allows us to put the property into the MLS, allows it to be visible to other members of the MLS for up to 15 days. The purpose to do this would be to like build excitement about the property. Potentially, maybe they have a tenant moving out, maybe they're painting some walls or whatever, but just like allowing the market to see that, hey, we have a property coming on the market and it's not ready to be actively shown yet. So as part of that, if you do check B, you must also check C, and a date must be filled in. There is also a form that is called the delayed marketing notice that must be done in conjunction with if you choose to check B or C. Now you can check C, but not B, but you cannot check B without checking C, if that makes sense. So if you're doing coming soon, you must also do the delayed marketing notice with the coming soon, and the broker has to sign that. And then you basically put in here what date you are going to put the house on the market. Now you're going to be entering this in the MLS when you enter the property. And if that needs to change, you need to contact MLS right away because it's hard to reverse that. If it goes from coming soon to active, then you are going to have to withdraw the property and put it active once it's ready to be active. You can't go back from active to coming soon. So you really need to watch that date. If that date needs to change, you need to make sure that you notify MLS, and they're probably going to want to see your documentation. So that's even more of a motivator to make sure that your paperwork is correct. If you check C, if you check B or C, a delayed marketing notice must be accompany the listing agreement that requires the broker's signature. I get these all the time. I can electronically sign them, very easy to do. Just make sure that you do that delayed marketing notice in the event that you check C. Now, D is probably the most confusing. That would be if the property is not going to be entered in the MLS and would never be entered into the MLS. Maybe it's a property transaction where they're like, we absolutely want no data whatsoever available to anyone on what took place with this property. You would check D. They just need to be aware that in the event they do check D, that they do not want their property in the MLS and then they change their mind, they would have to wait 180 days before being able to enter it in MLS. Again, if you check A, your property must be in MLS within 3 days of the commencement date. That's one big issue we're seeing. Number 2, this is another place that we're seeing either it be left blank or we're seeing some discrepancies between what we see on the listing agreement and what we see in the AREC. And we will be checking this. And I have to tell you guys, we are not doing this to be jerks. We're doing this because deals are a little bit harder to come by than they were 12 months ago. So it's important for us to make sure that any deals that are able to close do get to the closing table and that they're not slipped up on some little error here or there. And then just making sure that it's extremely stressful to have a complaint filed against you in any forum. And so just making sure that we have as little of that as possible, because it just takes away from your time and energy. And it just causes a lot of unnecessary anxiety. And it can just be, a lot of it is avoidable with just like paying attention and doing a good job on your paperwork. Okay, so number 2, licensee relationships. So you really have 2 options here. You have A or B. I would say 9 times out of 10, we see A checked. But the AREC does not always sit in alignment with checking box A. So what it says is licensees will only represent a seller unless the seller has executed a waiver of right to be represented In the event the licensee represents a buyer interested in the property, seller authorizes licensee to act in the following capacity, and they have checked A or B. So A, you would check if they have executed a waiver of right to be represented, and they have checked both, initialed both representing the seller only and authorized to act as a neutral licensee and executed the waiver. That is the only way you can check option A. I typically check option B because I don't ever represent, or I don't ever go neutral. If you check option B, this says seller has signed the Alaska Real Estate Consumer Disclosure, but has not executed the waiver of right to be represented form and does not pre-authorize the licensee to act as a neutral licensee. Seller understands that licensees will not show the property to any buyer who is represented by the licensee. So represented is really the key word here. This does not mean you can't show the property. It just means you can't show it to somebody that you are representing. So you can show it to them and provide specific assistance to the buyer, but while still representing the seller. And I would explain this to your sellers that that's how it would be handled. If they say, no, I don't want you having any dealings with any buyer that would be interested in my property. I just want you like talking and working with me. Then you would know that ahead of time. Again, a lot of these issues could be resolved right at the listing appointment. And you could refer them and know that those buyers are just going to have to be referred out. So hopefully that makes sense. So option A, you check if they have done the waiver of right to be represented and have initialed on the AREC that they are authorizing you to act as in a neutral capacity. Option B is if you're representing the seller only and you understand that any buyer under any representation. So if you've done a buyer's rep and you've initialed that the buyer is being represented by you, then you are not authorized to show this property to them if option B is checked. Now, I believe the best practice is for us not to go backwards in relationships. So in the event that you say, I'm going to represent the seller only, there's no authorization of neutral, it's pretty hard to back the bus up on this. And if you do, you better have a damn good paper trail of that, because there's nothing in law that says we cannot do that. But I have to think that if we were in court, how is that going to appear? We have to really think about that. What is in the best interest of our clients? So if you guys have questions about that, please reach out. But please make sure you pay attention, because we are also seeing that people are just simply leaving this blank, and it would be an incomplete and voidable contract at that point. So you need to check one of these. If you notice, there is not an option on here to provide specific assistance to a seller. This would not be the appropriate form to use for that, and we'll go over that here in a minute. This would be the terms, what we're going to list the property at. Broker is authorized to accept and hold earnest money deposits on behalf of the seller and prospective buyer. In the event that there is a price change that comes up throughout the listing period, that does require express permission, meaning written permission to change the price of the property. My preferred method to do that would be through the status change form and the MLS. You could also do that through an email. I do think that's a little less safe or less of an insurance policy if you're doing it that way, but it does need to be in writing. We are an industry that is governed by the statute of frauds, and we need to make sure that we have a paper trail of everything. I know a lot of you have heard my story about the price change that I made on a property, and then the guy told me he was on pain pills and didn't remember doing that. I'm so grateful that I had a signed authorization, because what if that was just a conversation over the phone? I would have been in a lot of trouble at that point. Okay, paragraph 4. Seller warrants that the seller has the right to sell the property on the terms herein provided, and agrees further to pay for a policy of title insurance showing a marketable title to the property. Seller agrees that interest on the loan being assumed, taxes, rents, insurance will be prorated to the date of recording unless otherwise agreed in the purchase and sale agreement. So basically, this is their agreement to provide title insurance and prorate any taxes, homeowners dues, things like that as of the date of recording, unless it is agreed upon by the buyer and seller within the purchase agreement. So we see this occasionally with like new construction where a seller purchases a piece of land on behalf of the buyer and they don't want to pay the property taxes. So they'll say no proration of property taxes will be taken at closing when they close on the property, and that the buyer will be responsible for all the property taxes up until that point. But that's pretty rare that it happens. So I've also seen where we'll get an offer on a property and they'll say, hey, their loan requires them to have title insurance. I'm not paying for that, when they had already agreed through the listing agreement to provide title insurance. So I just think we need to be going over this paragraph with our clients at the time of listing. Okay, paragraph 5, how are you going to get paid? So this number right here needs to be the total commission you are charging. So it could be 5%, 6%, 8%, 10%, whatever that might be. The total percentage needs to be right here. If you're doing a flat fee, it would be right here. And then of which the cooperating broker is to be paid. And so you put whether you're offering them a percentage. So if it's like, let's say 6%, and you're going to split that 50-50, you would put 3 in that box. Or if it's 5%, you put 2.5 in that box. If it's 10%, you put 5 in that box. 10%, you put 4 in that box. Whatever it is, whatever you're offering to the other side is what needs to be put here. Again, we see this left blank a lot. And I believe that is putting us in a position to where you would have a voidable listing contract at that point. And pay any applicable sales tax to the appropriate taxing authority not later than the date of recording when A, broker procures a buyer under the terms of this agreement or other terms acceptable to the seller. B, the property is sold or transferred by a seller to a buyer placed under contract during the term of this agreement or any extension hereof. We've had this come up once this year where a seller just went ahead and entered into a contract to sell his property outside of the agents, and we have the property listed and we're due a commission during that time. So where that's rare, I would just be explaining this paragraph to the sellers at the time of the listing. This is another place I see left blank, and it's really super important, especially where we're entering a market where we might see some more expired properties than we're normally used to. The property is sold or transferred within how many ever days. So I put 120 days on mine. Some people put 90, some people put 6 months, some people leave it blank. After the expiration or termination of this agreement to anyone who has shown the property through the marketing efforts of the broker during the term of the agreement, and provide that the property was not sold or transferred through another subscriber of the ACAM MLS. So maybe you have a listing that's about to expire in a week. You show it to a client and they're like, hey, I know this seller. And the seller says, hey, my listing's about to expire in a week. Let's let it expire and then I'll sell it to you after my listing expires and we'll save all this money. This paragraph right here is what protects you from that. If a property is withdrawn from sale, leased, rented without consent of the broker, or made unmarketable by the seller's voluntary acts during the term of this agreement, seller agrees to compensate the broker as above unless otherwise stated as follows. This would be a great place for you to enter if you're going to have a cancellation fee. I do have a cancellation fee in my listing agreement, and I just tell them it's kind of a good value proposition of like, hey, if something comes up, no harm, no foul. If you want to cancel this listing, that's totally fine. But you are going to pay me X number of dollars for my efforts and hard costs for pictures, marketing, black box sign, all of that. But it really needs to be here or in additional terms if you intend to collect on that. If you are paying a referral out to another company, it needs to be disclosed here and how much you're going to be paying them. This information authorization is kind of useless, in my opinion. It says it authorizes all mortgage and lien holders to provide broker information concerning the property, including but not limited to loan balances, things like that. We all know that they need some sort of payoff authorization or some sort of additional authorization beyond this for them to actually give you that information. It also authorizes you to like research utilities and things like that. Broker to use information to market the seller's property through advertising, including the internet. Broker assumes no liabilities for errors, omissions, and of inaccuracy or third-party internet sites. Seller acknowledges the broker may have limited ability to completely remove photos and property data once published on the internet. I think that's really important because when our properties go into MLS, they syndicate out to like 200 other sites. A lot of times once it's out there, it's out there. And so if there's a picture that they might not necessarily like, you might not have 100% control on getting those pictures off of those third-party sites without a lot of effort, or maybe not at all. So I think that's really important for them to understand that. It's also a really good motivator to make sure that their pictures are top-notch quality, not like, hey, let's just throw it on the market and see what happens, because it's a very good possibility they will be on sites that you will not be able to get those pictures off of. Okay, number 8, this authorizes us to put the property into the MLS and also to report the sale data when the property closes. Again, I like to tell them that we're not a public MLS, so this is not available to, this data is not available to the public, but it is data that would be available to other MLS members so they could use it for the pricing of other properties or for appraisals. Number 9, sign and lockbox. This is them authorizing you to put a sign and lockbox on the property. If there is a tenant occupied property, there is another form that I would recommend that you put in conjunction with this, that you have the tenant sign, that the tenant says you understand that there is going to be a lockbox on the property, and that neither the broker, AKMLS, or any subscribers shall incur any liability for loss, theft, or damage, like with regard to their personal property. But there is an additional form that's a tenant authorization for a lockbox to be put on the property. And if in the event that you're listing a property that has a renter in it, that additional form really should be signed as well. Number 10, super important one, during the term of this agreement, unless otherwise agreed in a separate agreement between the listing broker and seller acknowledges that A, seller is solely responsible for the property and its components, vacant or otherwise. Listing a broker assumes no liability for maintaining the condition of the property or providing security to the property. And C, seller has been advised to take steps to ensure maintenance, security, and upkeep of the property. So where this is particularly important is a vacant property, especially in the winter. What is your agreement or implied agreements with the seller regarding your responsibility for the property? I personally have had a vacant property freeze up, and they wanted to hold me responsible because they said, I listed the property with you. It's your responsibility to check on it, make sure that everything's working, whatever. And we kind of went back and forth of it. And I felt like I did give them an indication that I would be overseeing the property. And so I felt responsible, and I helped them pay for the damage that the freeze up caused. From that point forward, I have had a more direct conversation about what this looks like. I would recommend that you take no responsibility for it whatsoever, because I think if you take this much responsibility, they're going to assume you have this much responsibility. So if they have a property that's sitting vacant in the winter, I would start asking questions like, who's checking on your property? Who is plowing your driveway? Who's sanding your walkways? Things like that. And that you assume no responsibility for that whatsoever. There are companies that can do that on their behalf. And if they want referrals to those type of companies, I recommend you get them. But I recommend that you do not assume that responsibility, because you could be taking on a lot more than you think. It takes 8 hours for a house to freeze up. And yeah, I mean, it can easily happen. It happens every single winter to multiple properties, and it's just probably not a liability you're wanting to incur. And so I think if you say, hey, I'm going to go by the property once a week to make sure it's not frozen up, I think you're opening up for some issues there. I'm not saying you shouldn't go by the property once a week. I'm just saying that you should not assume responsibility for that kind of maintenance to the property. And you should really be communicating to the seller that that is not going to be your responsibility. Number 11, Seller agrees to provide a written disclosure statement concerning the condition of the property and agrees to save and hold harmless broker from all claims, disputes, litigations, or judgments arising from incorrect information supplied by the seller or from any material fact known by the seller that the seller fails to disclose. So this is saying that they'll provide a written disclosure statement. Obviously, that could be a waiver. I think waivers are probably utilized too often. And I think that's because we're not communicating to sellers that providing a waiver does not relieve you from your obligation of disclosure. So I would really encourage the full form if it is appropriate for the property. Now, the state of Alaska property disclosure is only required on residential properties that have 2 dwellings or less. So a fourplex does not require a disclosure at all. It does not mean you don't have to disclose things, but it's saying that full form is not required. Tax withholding, seller warrants that they're a U.S. citizen, permanent residents, or other exempt from the requirements of the FERPTA. So I like to just ask them, are you a U.S. citizen? 99% of the time they are. I have sold one property recently that they were not a U.S. citizen. They were a citizen of Japan. And that requires some special tax withholdings at closing that they need to be aware of before entering into a listing agreement with you. I believe it's 15% that they hold back automatically. It's not that they won't receive some of that later, but they hold back 15% of the proceeds no matter what, unless you are a U.S. citizen, permanent resident, or exempt in some way. Number 13, equal housing opportunity. We offer properties in compliance with federal, state, and local anti-discrimination laws. We cannot discriminate against, a really good way to say this, just like we can't discriminate against anyone who is willing and qualified to purchase your home because of familial status, race, all the protected classes. This is not a fair housing class, so we won't go into that at all. But I think it is really good to go over this line with the seller, because at that time you will possibly hear prejudices. And I think they're not necessarily always what we think they might be. I have heard like, I don't want so-and-so to buy my property, or I don't want, this isn't really a kid-friendly neighborhood. So I think it would be best if, somebody that is not a family does not buy this property. Or I've even heard like, I really would like a family to own this home. That could potentially be discriminatory to people that do not have a family, that are maybe single people. So just be aware of that and read that line and make sure that the sellers understand that you cannot discriminate against anyone who is willing or qualified to buy your property regardless. It is a legal binding contract. So if there is a dispute arising, there's 2 things that they need to be aware of. One, they are agreeing by signing this contract to try mediation prior to litigation. And if it is escalated to the level of litigation, if it's escalated to the level of litigation, the prevailing party has the right to go after reasonable attorney fees and costs. Okay, other terms. This is a good place to utilize special terms. This would be a place where you could enter your cancellation fee if you didn't want to do that on page 1. This would be another place that you could enter how you're going to handle multiple offers. You could say, maybe agree up front, hey, if we get more than one offer on this property at the same time, do you want me to disclose the existence of offers to the other parties, or do you want to deal with it on a case-by-case basis? In our Code of Ethics, Article 1, Standard of Practice 15 deals specifically with this. I'll read it to you because this always comes as a surprise to a lot of people. We were just dealing with this in a class. I was just taking an ethics class down here in Hawaii, and we were talking about this specifically. So I like to read this because a lot of times people do not understand what this says. So Article 1, Standard of Practice 15 says, realtors In response to inquiries from buyers or cooperating brokers, with the seller's approval, disclose the existence of offers on the property. Where disclosure is authorized, realtors shall also disclose, if asked, whether offers were obtained by the listing licensee, another licensee in the listing firm, or by a cooperating broker. So what that means is you must obtain the seller's permission to disclose the existence of other offers in the event of competing offers. So that means just because another agent calls me and says, do you have any other offers on the table? I cannot say yes unless my seller has authorized me to do so. The listing agreement would be a perfect place to kind of pre-authorize this and really discuss and solidify in writing how offers are going to be dealt with in the event that there are multiple offers. It's also a great place to deal with variable rate commissions. So sometimes you'll see people say, I'll write it on here. Let's see. Something like, in the event that Devon Doran procures the buyer on this property, commission to be reduced to a total of 5% of the purchase price. If you do something like this, that is creating a variable rate commission. And in order to be able to follow MLS guidelines with a variable rate commission, you must A, have it in writing, B, have it disclosed in your listing. So there's a checkbox when you're inputting your listings that says variable rate commission. If you do not have that, you would not be permitted to reduce your commission in the event of competing offers in order to like gain an advantage over a potential other buyer and their agent. Another thing that is common is they say, hey, a guy at my work wants to buy this property, but if he doesn't buy it, I want to list it. I still want to list it, but I don't want to pay you a commission if the guy at my work buys it. So you could say, Joe Smith shall be excluded from the terms and conditions of this contract. I would recommend taking it a step further and putting an expiration date on that till, let's say, February 28th, 2023. The exclusion shall no longer exist. Something of that nature. I would always recommend putting a deadline on it. That way you don't have a listing for a year. You've spent all this time in marketing on it, and then Joe Smith from their work decides to buy it and you get nothing. Seller has read this agreement, understands it's a legal binding contract, has been advised to seek independent or legal tax advice. We should always be reading this line to them. We are not attorneys. We are not accountants. We have no idea if they're going to have to pay capital gains. We have no idea what would happen in the event of certain types of contractual disputes. The seller acknowledges they have received a copy of this agreement and the attached property data sheet. You should always be sending them a copy of their MLS data just to confirm that what is in there is accurate. We have had some issues with this. Specifically, ones that I've seen is square footage discrepancies. Somebody put in that something had in-floor heat when in fact they had forced air or baseboard. I would always be sending it to them. I think even taking it a step further, if you want to be extremely prudent in this, is to have them initial it and say, hey, looks good, no changes needed, but send them what is in the MLS. There, you could send them the actual checkbox form. I prefer to send them what I actually enter in the MLS because I've had them catch my mistakes. And I found that they don't typically mind if you catch that you've made a mistake and they catch it when it's immediately on the market. What they do have a problem with is a property that's been marketed for 60 days with incorrect information. I hope that makes sense. I just want to go back to a couple forms and then we'll wrap this up. Again, we're going to look at page 1, paragraph 2, right here, licensee relationships. We want to make sure that what is checked here is also matches what they have authorized you to do here. And we check these. We check that what's on the AREC is actually what's authorized in the listing agreement and vice versa. So if we're rejecting these documents, it's because it is outside the statute. And technically you could be brought up on a complaint with the real estate commission for this form. That's why we're checking these so heavily. We're not doing it to be jerks. We're doing it because we don't want any necessary headaches. Because I would say 99% of this time that this happens, it is not a malicious act. It is just, I mean, simply like ignorance, sloppy work, just being kind of lazy. I just want to touch on couple things. I think I went over everything with the exception of for sale by owners. So I get a lot of questions about for sale by owners and how to deal with them. Number one question I get, do we still need to execute an AREC? Are you going to be communicating with the seller? You probably should be doing an AREC for them. I know it gets a little tricky when they're represented by a for sale by owner company and listed in the MLS. Maybe that's an area that it wouldn't necessarily apply. But if you're dealing with a true FSBO that's just literally put a sign in the yard, maybe put it on Craigslist, but is not in the MLS, you would absolutely want to do one of these just to protect yourself. And you would have them check specific assistance, or sorry, initial specific assistance without representation, and that you're representing the buyer only. You still are obviously are able to provide specific assistance to the seller. It's very, very prudent to do this. It is not correct to have them do a listing agreement at that time, because like I said, there's not an option to provide specific assistance to the seller through our authorization and exclusive right to sell. One of these two forms would be the most appropriate to do in connection with the AREC, which would be the authorization to present earnest money. So let's just fill it out. Let's say Joe Smith is the seller, authorized Signature Real Estate Alaska and its licensees to accept earnest money for the sale of the property located at 123 Main Street in the Palmer Recording District, and held in trust by Signature Real Estate Alaska until close of transaction. I understand that by signing this authorization, it in no way creates an obligation to accept any offers. This doesn't require them for me to bring them an offer and them to accept it. It only authorizes Signature Real Estate to accept earnest money and to present offers on the above referenced property. I understand my property is not listed in the MLS service and will not be advertised. I agree to pay Signature Real Estate a commission of, sometimes it's a flat fee, $10,000, or you could put 3% in the event of a successful sale. This authorization shall expire on signed date, buyer seller. There is also this one, which is agreement to show. It's a little bit more lengthy and in depth. And you guys, both of these forms are listed as with the heading FSBO in Signature Docs and should be done in conjunction with an AREC. This would only apply in the event that this property is not listed in MLS. So I know that there's a lot of FSBO companies that list in MLS. You would not need to do this form for those. Only true for sell by owners, traditional ones where they, like I said, hang a sign in the yard, put it on Craigslist, and have no affiliation to any real estate professional whatsoever. Okay, so that is all I have for today. I just want to wrap this up by saying, please, 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 if you got anything from this section right here is where 90% of our problems come in. Please pay attention to the boxes you're checking and that you are filling them out appropriately according to what's in agreement with what you've discussed with the seller. Make sure that your seller has legal authority to enter into this contract and that the appropriate boxes are checked in the event, whether it be like you're listing it, it's going on the market in 3 days, you're listing it, we're going to put it in coming soon for 15 days or less. Or, hey, I'm taking this listing agreement now, but we're not putting it on the market for 30 days because we're replacing the carpet and have it painted. That would be option C. And that your correct licensee relationship would be checked. Again, A is if they have done, you're checking A if you've also done the waiver of right to be represented at the time of listing. You're checking B if you have not done the waiver of right to be represented. And like I said, whatever you choose on option A or B, it is really difficult to go backwards. So please make sure you really, really put some thought into how you're executing this document so that we can make sure that it's good. And that it's in compliance and that we don't have any issues. This should never, never, never be left blank. Paragraph 1 and 2 should never, ever have any blanks whatsoever. We have seen a little bit of people leaving the listing price blank because they haven't decided what the listing price will be, but they're going to enter into a contract. In the event that you add this later, if it's left blank, we're going to reject the document. I'll tell you that right now. If it's added later, I would like to see an initial by it by the seller. I think that is it for today, guys. I'm really, really hoping this helps alleviate a lot of problems, a lot of stress on Maddie for having to track down documents that she's rejected, and that moving forward, we can just have better, cleaner paperwork and very, very few issues pertaining to listing agreements. I hope you guys are all doing really well. I miss you all. I will see you guys all in the office next week. Don't give Jim too much of a hard time, and I will talk to you all soon.